Court convenes today to honor and remember the life and career of Justice Robert L. Clifford. Your presence, all of you, is but one sign of Justice Clifford's lasting influence on this court and its members and on the entire legal community. Let me start with just a few words about his continuing contribution to the court today. When I arrived, I had heard about his famous wit, about his reputation for scholarship, dignity, elegance, and his role as the court's grammarian and editor was not only widely known, but it remained a force and continues as of now. From time to time, as members of the court would wrangle over just the right way to say something in opinion, invariably someone would say, "This is what Justice Clifford would have done," and that would settle the matter. I took that to heart, and when I completed my first opinion, and it went out as a published opinion, I sent it to the justice and asked him if he wouldn't mind marking it up, having a read, and editing it. And he did just that. He readily took up the challenge, sent it back in a few days with a fair amount of ink spilled in a number of spots, fair comments all, and I have been told since by a number of individuals that he was gentle in terms of the number of comments that he offered. But one edit stood out above all of the others. It was a 17-page opinion with one footnote. And even that solitary footnote was too much for the justice. He sent it back, and beside the footnote, in big, bold letters, capitals, were N-O with 4 or 5 exclamation marks next to it. And each time that I've inserted a footnote to an opinion, and I'm from the Clifford School and try not to do that, I always imagine the grade that he would be giving me if he were going to be reading it and evaluating it again. A few weeks ago, I asked Donna Anapete, whom I'm assuming everybody here knows, who served with the justice and has a wealth of knowledge about the court, if she had any stories that she could relay about the justice. And she gave me a letter that Justice Clifford had written to Stephen Townsend, then clerk of the court. Stephen, we're so glad to see you here today. And it was a letter asking him to replace a draft opinion that he had previously circulated with a new one for filing. Just by way of comparison, those letters usually say something like this. Dear Stephen, enclosed, please find for filing the dissent in Smith versus Jones. Very truly yours. This letter by Justice Clifford, dated December 23rd, was a little different. It related to a debate about the word volunteer and the meaning of the concept to volunteer in an opinion. And the letter really speaks for itself about the justice's magnificent and inimitable style. Here's what he wrote. Dear Steve, I've returned from the woodshed, bloody and bowed, admonished, chewed out, and thoroughly cowed. Tear up that filed draft the High Sheriff proclaimed. If that ever goes public, this court will be maimed. Compliant, submissive, sans hint of a jeer, I've tried one last time to explain volunteer. My prospects are winning, are skimpy for sure. More likely they'll see me as wimpy, but pure. Pure as the snow that arrives with the season. The High Sheriff's bidding is good enough reason to abandon conviction and show some good cheer, to bask in the joy of a happy new year. So forget my first effort, give all my sibs glee, just file this revision, your friend, RLC. One of a kind.
The justice whose memory we honor today, Robert L. Clifford, was as proud of his membership on this court and as dedicated to the preservation of its reputation for excellence as any justice I have known. In addition to his 1 year of service as a law clerk to the late Justice William Wachenfeld, Justice Clifford served on this court for 21 years, from 1973 to 1994. His tenure was the third longest in the modern court's history, exceeded only by Justices Nathan Jacobs and Alan Handler. For 10 of those 21 years of his service on the court, 1985 through 1994, he and I served and participated together in this court's deliberative and decisional work. His influence was enormous. He was among the court's least predictable justices. Because he had spent most of his legal career as an insurance company defense attorney, he was an unlikely champion of plaintiffs' rights, nor was it expected that he would turn out to be a stalwart protector of the constitutional rights of individual citizens. He was neither a liberal nor a conservative justice, but his votes and opinions were shaped by a strong belief that the court's decisions, although informed by law and precedent, had to conform to an overriding standard of fairness and justice. A sample of his majority opinions illustrate his vast contribution to the court's jurisprudence. In 1981, he wrote the majority opinion in Beck versus Beck, holding for the first time in New Jersey that trial courts in child custody cases were authorized to grant to divorced parents joint custody of their children. In Smith against Ricci, he wrote the court's opinion upholding against a free exercise and establishment clause challenge, a State Department of Education regulation requiring all school districts to develop and implement a program for teaching family life and human sexuality in the public schools. In State v. Hempeley, he wrote the court's majority opinion holding that under our state constitution, law enforcement officials needed a search warrant based on probable cause before they could conduct a search of household garbage left at the curb for pickup. With characteristic understatement, his opinion acknowledged the fact that the United States Supreme Court and the vast majority of other state courts disagreed. He wrote, "We are aware that our ruling conflicts not only with the United States Supreme Court's holding in Greenwood, but also with the holdings of virtually every other court that has considered this issue. Although the weight of the cited authority is impressive, our thorough consideration of the issue leads us to record our respectful disagreement with those courts that have reached a result contrary to ours." In State versus Hartley, where's Mary Thurber? There she is. Judge Thurber was Justice Clifford's clerk when he wrote this opinion. Defendant was the lookout for a jewelry store robbery that resulted in a double murder. He had invoked his right to remain silent after receiving Miranda warnings at 7:30 and 9:15 on the morning of his arrest. At 10:40 a.m., an FBI agent approached Hartley and, without administering new warnings, told him that if he was going to make a statement, now is the time. Hartley confessed, and in a 5-2 decision written by Justice Clifford, the court held that the confession was unconstitutionally coerced because the FBI agent had failed to re-administer Miranda warnings when he reapproached Hartley and therefore failed to scrupulously honor Hartley's right to remain silent. That might have been the last time I dissented from one of his majority opinions. But as I'm sure everyone here knows, his contributions to the court's opinions went far beyond the ones he authored. During the 10 years we served together, and beginning many years before that, Justice Clifford edited, both for grammar, Blue Book style, and substance, every opinion circulated by every member of the court, adding innumerable hours to his already burdensome workload. He explained to me once that editing was irresistible to him, and that he also edited Time magazine whenever he read it. Maybe so. But I can attest to the fact that his edits were of incalculable value to the quality of the court's work, not only the opinions, but the writing ability of every justice and every law clerk exposed to Justice Clifford's merciless red pen were permanently enhanced by the experience. In my own case, practicing law currently in a firm with 30-some attorneys who frequently ask me to edit their briefs, not 1 week goes by in which I do not change a which to a that, or vice versa. Relocate the word only to a position later in a sentence. Substitute although for while. Change these to those. Replace since with because, and substitute concerning for as to. Every one of those corrections for me is reflexive because they were drilled into my subconscious by Justice Clifford's repeated and unyielding corrections of my draft opinions. So if ever a justice did it all, conscientious and meticulous preparation, authorship of elegant opinions, a prodigious work ethic, including hours of extra work editing our opinions, and all the while enhancing morale and collegiality with a sharp and penetrating sense of humor. That was Robert Clifford, a man whom Justice Daniel O'Hearn characterized in his book on the court as the indispensable justice. And so he was. For me personally, he also was an indispensable friend. Thank you.
I think you'll recall there was nothing about Robert Clifford that was out of touch with life in the legal fast lane, then or ever. Throughout his many years on this court, he bristled with relevance in his opinions, in his interest in the law as it was being practiced, and in his passion to write and edit with precision, so that however imperfect we are as human beings, the court, when it decided a case, got it right. Such is the fate of a law clerk, that I will be forever dazzled by him because he was my judge. Wherever we came from, the Clifford clerks in attendance here all share the same experience. The dawning recognition in the fall of the clerkship that we were in a special relationship with special people, the judge and Ruth, and that we had older and younger siblings of a sort, the clerks from the other years. And then as the clerkship year went on, and in the ensuing years when we get together, came the full flowering of the boneheaded, arrogant conviction that our year, without question, was the best one that the judge and Ruth ever had. Right? And they never let us down in that blind belief. I miss him and those precious times more each year, and I wrestle with why. I know that whatever a Clifford clerk learned about the law and lawyers and the practice of law wasn't furnished by self-conscious preaching or by scaring us straight. Rather, the judge and Ruth were themselves, always. Not suffering fools, but never petty. Meticulous about the craft, but never mean-spirited. Endlessly tolerant of our clumsy efforts to manage the prestige of the position his clerkship represented, so that we turned out to be a group of self-deprecating, but confident and finally fine lawyers. We modeled ourselves on him, and we leaned on her, and year after year they guided us and then gently disengaged us. They did that with food. They did that with fun. We know how much we laughed. And with an open door, always a wide open door, so that after we tittered out, we could always slink in or bound in, but never strut. Ultimately, we learned a lesson that perhaps our profession has lost faith in: humility. He made it clear that one does not take for granted the great privilege we had of being with him and of being lawyers at all. That our foibles could trip us up, and so be very, very grateful for a smooth ride and have compassion for those who stumble. And get up and without rancor push on when we ourselves stumbled. No, he never said that. He showed it in his dealings with the countless friends who'd stop by chambers, with the other members of the bench, with the stories he'd tell that were full of affection, even as they were richly funny. He showed us with his fierce loyalty to the judges he admired: Justice Mountain, Chief Justice Hughes. The lawyers who came after Joe's and my year can add to that list. And he showed it in his fierce loyalty and love for the lawyers he practiced with, and with his deep understanding of what a lawyer's life is made up of. I came to understand in retrospect why he closed the door to his office, something he rarely did, and labor over ethics decisions we were never a part of and that he never talked about. Always, he demonstrated his affection and respect for the entire court family, every person who made the Supreme Court function, and every employee in the Morris County Courthouse. We learned manners, if we didn't have them already, and we learned that this elegant, wonderful-looking man, perfectly turned out in his irritatingly understated, always correct attire, could connect with each person he encountered and make that encounter warm and easy, for no other reason than it mattered. When you think of it, in those remarkably few months, he taught us that scholarship matters, and because of that, grammar matters, and at all times, manners matter. And that is priceless knowledge he instilled in each of his clerks. With that recognition, late last night, I finally resolved why my sense of him is so keen and getting keener. It isn't missing him exactly. That tug is coming from his restless spirit, growling, harumphing, editing, pushing at me not to get soft, not to get comfortable, to make it better, to be disciplined, to reason, to cull, to fuss, to create, listen, try.
Bob was many things to many people. To some of you, he was a colleague, a friend, and a mentor. To a few of us, he was a father, a husband, a grandfather, and an uncle. Ruth asked me to share today some memories of him at home. And by the way, I know if he's listening, he hates this already, but here goes. Bob was notoriously difficult to buy presents for. For years, his suggestion to Ruth for birthdays, Christmas, and anniversaries was red Jell-O. My mother always made it for me, he would remind her. The year Gordon and I got Bob's name in our family Christmas gift lottery, he said, as I expected, I don't want anything. But then he had an idea. He asked for a V-neck, cashmere sweater, orange, size medium. Thanks, Bob. This was before Amazon, and I live in Vermont. Not a lot of shopping experiences there, but we did manage to find the sweater, and he loved it. Bob was more enthusiastic when it was someone else's birthday. In fact, he and Ruth never missed one, and she still doesn't. The call would come sometime during the day, a duet of happy birthday with piano accompaniment. Whether we were lucky enough to catch it live or listen to it on voicemail, it was always a treat. Ruth says that Bob was her college education. He introduced her to jazz and opera and helped her with her writing. In fact, as everyone has mentioned so far, Bob took his position as grammar policeman very seriously, and it's a role many of us are familiar with. Dinner conversation could include a rant or two about nominative and subjective pronouns, split infinitives, or punctuation. So I was a little more than nervous when Bob asked for a copy of a book I wrote on grammar and usage 10 years ago. I should have known that it would be returned to me, edited in red pen. But it's still a point of pride, though, that most of the errors he found concern my misuse of the word only. No misplaced modifiers, no confusing the words that and which, no faulty comparisons. I felt I passed the test. When they were home, Bob and Ruth loved their weekends. After breakfast on Saturday morning, Bob would head upstairs, armed with the boxes Charlie had delivered on Thursday containing the court's work for the following week. He went to his office on the right, and Ruth went to her sewing room on the left. They met for tea in the morning, and then again for lunch. He might have a nap, and Ruth would listen to the opera, and they met again for cocktails and dinner at 6. My aunt says the routine was identical on Sundays, minus the opera. These infamous homebodies did, however, venture out on occasion. One of Ruth's favorite memories is of their trip to King's College, Cambridge, for the Christmas Eve service, a retirement gift from their law clerks. Ruth had introduced Bob to the broadcast of that service years before, and he said that someday he would make it there. The clerks made that possible. That wonderful trip stands in sharp contrast to the one they made to Scotland 5 years later for one of our family weddings. He said afterward that he didn't realize what he was getting himself into. Scottish country weddings last a week during which he understood not one word of what anyone said. Ruth played the role of translator. Bob also loved to eat. I'm sure many of you know this, and Ruth loved to cook for him. He enjoyed food to the very end. Thanksgiving morning, he had his usual breakfast of soft scrambled eggs. By the afternoon, our whole family was there for dinner. He sat down at the table with us, but just before the meal was served, he decided to go to bed. We didn't know then that that breakfast was his last meal. As always, though, it was, as he said, good eats.